Mr. Fritz.
Chairman Pierce, members of the board, thank you. Good afternoon. As I said this morning, I'm here on behalf of the Coalition for a Democratic Workplace. And CDW's position is that the proposed 20% rule is inappropriate and violates the Act. But I would like to hold aside those legal arguments for purposes of my remarks today and focus instead on some practical questions raised by the 20% rule. I didn't see anything in the ground rules that prohibits me from asking the board questions, so I'm going to take the liberty of doing so, not with the expectation that the board will answer the questions on the spot, but I do believe that they're questions.
Or at all.
Or at all.
I may hide under this structure.
The hot bench is here now. So, but I do think these are important questions for the board to consider as it deliberates on the proposed rule. And so the first set of questions relates to how the 20% rule would apply in the case of an election agreement. Under current procedures, a regional director generally will not approve an election agreement if more than 10% of the proposed unit will be subject to challenge after the election. And so that raises a question as to whether the 20% rule would also change that standard with respect to election agreements, or whether the standard for election agreements will be different. If the standard is changed for election agreements so that an election agreement would be approved if up to 20% of the unit will be subject to challenge post-election, that opens the door then to more post-election litigation, even in cases when you have an election agreement. Second set of questions relates to the practicalities of how a hearing officer would apply the 20% rule. And the first question I have is, if at the outset of the hearing there are eligibility or inclusion questions that in total affect more than 20% of the proposed unit, how will the hearing officer decide which issues to take evidence on and which it will not? Will the hearing officer take evidence on all of those issues because in total they are more than 20%? Or will the hearing officer take evidence on some of them to get it below 20% and then defer the rest? And if the answer is yes to the latter, then how does the hearing officer decide which one will get below 20% and which one will be deferred? So I think those are some practical questions in terms of how that rule would get applied. And then if there is an argument by the employer that the petition for a unit is inappropriate because it excludes certain employees, will the 20% be measured based on the larger unit that the employer contends is the only appropriate unit, or will it be 20% of the petition for unit? Third, the proposed rule doesn't clearly state how the 20% rule, or if the 20% rule, will apply to unit scope issues under specialty health care or any other standard. And let's take an example where a union files a petition for a unit of 50 employees. The employer contends there are 8 employees in a different job classification who are excluded but should be included because they perform the same or similar functions under common supervision at the same location. And so the employer is arguing that that's the only appropriate unit is a unit of those 58. As I read the proposed rule, the employer would have the right to litigate those 8 employees, whether they should be included, because that is a scope of unit issue, and the proposed rule states that the unit must be found to be appropriate before the election. But this is not clearly stated in the proposed rule. And the rule also talks about offers of proof, and it's not clear the extent to which, even if the employer has the right to litigate those 8 employees as an appropriate unit issue, whether the hearing officer could only take offers of proof on those issues, or whether the employer would actually have the right to present evidence on that. So if the board does decide to adopt the 20% rule, I think guidance is needed on these issues. And if I'm wrong, and the proposed rule would preclude the employer from litigating that unit scope issue involving less than 20%, then the final rule should so state as well. CDW doesn't believe these issues should be deferred, but these are, I think, important questions that the board should consider as it deliberates, as I said, on this rule. Thank you.
Thank you. I appreciate those concerns. I do have a question, though, about, you mentioned in the beginning, the application of the 20% rule to STIPs. And if the parties have agreed to do that, haven't they basically, the parties decided that they are willing to defer those issues if it's a STIP?
In my experience, I've had the situation where the regional director will not approve this STIP because there's more than 10%.
But the parties wanted to do that.
Yes.
And so do you think the parties should be allowed to do that?
I mean, I think in that situation, I think it depends on the case. I think in some cases, if the parties agree, then I think the regional director should have some discretion to do that. Maybe there's a point at which that becomes excessive in the sense of
an agency issue,
right? And it leads to too much uncertainty in the election in terms of who's in, who's out, and it leads to too much post-election litigation. So I'm not suggesting that that would be a discretion without limits, but whether you push the 10% to 15% or something like that, maybe there's some discretion there.
I have just a technical question, and found a number of your questions to be helpful. I wish I knew the answers to all of them. The point of the Act is not merely to have elections, it's to have elections that give effect to employee sentiments regarding union representation. And that means if employees select a union to have bargaining relationships. To the extent that we adopt a rule that simply moves forward with the election and gets some of these issues wrong, including issues that are under 20%, what's the available means by which those issues can end up being resolved? And when do those get resolved if the election has taken place based on a kind of misapplied set of premises about some of these eligibility issues?
Well, I think it depends on the outcome of the vote. If the vote is such that the margin is more than the 20%, they may never be resolved. Or there may be cases in which it is determinative, and so it's resolved in post-election litigation. But at some point, depending on the margins, it may be sort of, in effect, deferred to the parties to then work out either in bargaining or in possibly a subsequent UC proceeding. And we've addressed those in our comments.
And if a certification is based on an election in which a small number of employees were improperly included or improperly excluded, what's the means by which that gets resolved, and how long does that take?
Well, it could take a while potentially. I suppose there are a number of different ways it could play out. If the employer is contending that that is an issue that affected the results of the election, it's in effect something that taints the election result, the employer may choose to refuse to bargain, have a technical 8A5, and that ultimately could get tested in a court of appeals. If it was never litigated, and if there's no evidence on it, then there's the question of what's the record in that certification test case. There isn't one.
And if it turns out that the outcome, that the election in fact was based on premises that were just off, and if the certification is tested in that way, how long does that take to resolve?
Well, potentially, you're talking about court of appeals litigation. You're looking at something that's measured in a year, 2 years, and then in all likelihood, if the Court of Appeals finds merit to that employer's argument, the case would have to be remanded back to the board to take evidence on whether the individuals should have been included or excluded or whether they are supervisors. So you're probably talking about a process that could take a year, 2 years, or even more.
Are you talking about a situation where a determination was made, right?
No, I'm talking about a situation where a determination was not made because.
So people were not either included or excluded?
No, I'm talking about a situation where they were allowed to vote, subject to challenge.
Right.
But the challenges, based on the results of the election, were not determinative. So there's no need to ever take evidence.
Right.
And so the employer's only recourse then is to refuse to bargain in a technical sense.
Wouldn't it be the case that if a union decides to forego litigating a supervisory issue because it would have a negative impact on them being able to get to an election, the union cannot file a technical 8-5. Isn't that true?
That's true.
And they certainly had no forum to litigate post-election that issue.
That's true. I mean, theoretically, what the union could do is file a subsequent petition to represent individuals who are excluded if they believe they should have been included, and litigate it in a separate R-case proceeding.
Right, which creates more administrative process. Right?
True, but I think either way you're talking about more administrative process. If it's the employer's 8A5 challenge, or if it's a UC proceeding to resolve it after the fact. I mean, either way, if you don't resolve the issue, there's the potential for subsequent litigation.
Right. Okay. And the notice of proposed rulemaking provides for an administrative procedure for the issue in the event that the issue is still would be determinative of the results.
If it's determinative, then there's a post-election process.
Right. Okay. All right. Thank you all.
Thank you.